I'm Joe Romano, a member of the Burns-White Workers' Compensation Department. I've been practicing workers' compensation law for about 10 years. I solely represent employers and insurance carriers in workers' compensation claims. As for litigating COVID-19 claims themselves, there is really no legal guidance to provide right now beyond just basic premises of law that we have all grown accustomed to. I know that COVID litigation is going on right now as to claims that were sustained or potentially sustained at work. However, there is no legal guidance beyond the law that we all know as it stands right now. The claimant must be able to sustain their burden of proof that they contracted COVID-19 at work. They have to have sufficient evidence of exposure, and in many cases, they'll have to have a sufficient medical opinion supporting the causal relationship between the exposure and the eventual COVID-19 diagnosis. As for the defense side of the claim, my preferred medical expert in these claims will be an infectious disease specialist. I believe they are the most appropriate person to review the medical records, review the causation facts, and render an opinion as to whether the COVID-19 is causally related to the exposure or alleged exposure at work. At the end of the day, I believe all of these cases will turn on the specific facts regarding the alleged exposure. Because of this, the initial investigation is of the utmost importance. The moment a claim is provided regarding COVID-19, the employer needs to communicate information to the insurance carrier or to the third-party administrator regarding the potential exposure at work, regarding other issues surrounding COVID at the employer's place of business. They need to provide a correct and accurate timeline regarding exposure and the various times that the injured worker was working. There also needs to be details regarding the work settings, how closely the individual is interacting with other individuals, so that the most intelligent decision can be made regarding accepting or denying an alleged claim. Additionally, it is necessary to investigate with the injured worker as to details surrounding not only their exposure at work, but their personal lives. It is necessary to obtain information as to who the individual lives with, what their daily routine is, what the family's daily routine is, any other individuals that they may have encountered who have also been infected. They need to discuss also other individuals who they have been around that may have had symptoms without an official diagnosis of COVID-19. It's necessary to inquire on recent travel, as well as what they do in their personal time outside of work in the evenings, for example. Are they going to restaurants? Are they going to any sporting activities? Are they taking their children to t-ball practice? Anything like that will impact a potential decision to accept or deny a COVID-19 claim. At the end of the day, there is no one-size-fits-all analysis to determine whether you want to accept or deny a COVID-19 claim. Every claim will be different based upon its own factual scenario, again, highlighting the importance of an initial investigation. It's also important to ignore the fact that an individual may have sustained COVID-19, they may have recovered in 3 or 4 weeks, and you view the claim as simply a 4-week indemnity exposure with some minor medical bills. At this time, the research and the science isn't there to tell us what the long-term impact of COVID-19 will be. However, I believe it would be short-sighted to simply assume a person has sustained COVID-19, missed work for 4 weeks or so, and then returned to work with no further medical. It is certainly possible that in 2 or 3 years that we may learn that there were far more complications associated with COVID-19 than simply the initial disease. Therefore, I would be hesitant to simply make an acceptance or denial decision solely on the 1 to 2 month span of time after the COVID-19 diagnosis